As a lawyer, when a client comes to me and says, there's been this breach and we're concerned about potential mass claims, sometimes the answer is to just keep very, very quiet. Now, obviously, there may be instances where you may have a obligation by, for example, a regulatory body to make that notification. But often it's the case that actually what you're waiting for in these instances is for the attention to be deflected. In the Marston's case, which my firm's currently involved in, and I can't really talk too much about that, but certainly in the Construction Association case that I was previously involved in, that was certainly one of the tactics that was actually employed by a number of the companies. There seems to be a correlation between publicity and the number of claims that you actually receive. So as I said, the breach notification requirements in the US have existed for a number of years. And there's some interesting data that comes out of that, and I'll come on to that in a second. There is, for example, federal laws and state laws which require notifications to be given in certain circumstances. I've been provided this data by a company called Epic that runs a number of the call centers in the US, and it's quite interesting to see some of the actual statistics that have come out as a result. Over a 5-year period, going from 2010 onwards, there were about 200 breaches in a year. And what we've actually seen over that period of time is the level of call-in rates from individuals following a notification to have actually dropped. And there might be a variety of reasons why that's happened, which I'll come on to. What we see is that actually in the education sector and the employee sector, so in the type of Morrison's type situation of the Construction Association system, you tend to see a much higher call-out rate than you would, for example, in the retail sector, where there's actually a much lower call-out rate as a result of a breach. You'll also see that over that period of time, the rates are now about 1.5 to about 2.1% of the number of notifications that have been made. In all these instances, the notifications that were made to the individuals were made by post, and the evidence suggests that actually that results in a higher level of a call-in rate. The next slide is perhaps not surprising. What it also shows is that actually the older demographic is more likely to respond in the event of a breach notification than the younger age groups. Now, there could be a variety of reasons for this. It may be the case, for example, it's down to a bit of fatigue. People realise that as part of modern-day living, there will be breaches, and they get in a letter, and so one can't underestimate public apathy to picking up the phone, finding out what's the reasons for the breach, and potentially then contacting a lawyer. Now, the notification regimes, though that will be introduced as part of the GDPR, though, could cause us as litigators quite a bit of a headache. One of the problems in relation to previous claims situations were that the individuals simply didn't know that they can contact lawyers and actually make a claim. So, as a result of this, we might start seeing actually a rise, for example, in the number of civil litigation claims and these mass claims that Tim's been speaking about. There might be another explanation, of course, in the US. Following the Anthem breach a few years ago, there has been credit monitoring services that have been offered to individuals. And what we may see as this credit monitoring service finishes is that actually the levels of call-in will start to increase.